Good morning, everyone, and welcome to the webinar on software patents for artificial intelligence and machine learning technologies. We'll just wait a few seconds until more people enter the room and we'll get started. In the meantime, I'll just let you know that this session is being recorded and that the PowerPoint will be sent to you at the end of the session. We also will have a question period at the end of the session, so we ask that you hold your questions till the end. And you can enter your questions in the Q&A box located just at the bottom of your screen. Now a few words about our speaker, Natalie Raffoul. Thank you, Natalie, for being here today and presenting on this very interesting and important topic. Natalie is a world-renowned IP expert in patenting and licensing software. She is a lawyer in Ontario and a registered US and Canadian patent agent with a background in electrical engineering. She is a managing partner of the Ottawa-based Brion Raful, a boutique firm specialized in IP, and she is also the co-chair for the intellectual property courses that we run at McGill University. So now, without further ado, Natalie, I pass on the microphone to you.
Thank you. Thanks, Lucy. It's a pleasure to be here today, and I'm excited that we've got fairly good attendance to talk about something that is sort of near and dear to my practice, which is great. So we're going to talk about patenting in the AI and machine learning space, but really we're going to talk more broadly to start about patenting and then also get into some of the rules and regulations around patenting software and get into some examples too to color that for you. So just give me a minute here. So just Lucy gave me a great introduction there. I just wanted to mention also that I started the firm with Art Brion about 12 years ago. So I consider myself to be a bit of an entrepreneur as well. And I'm an advisor to a number of startup companies and invested in a few myself. So for you entrepreneurs out there, I'm with you, and I understand the challenges. And I just wanted to also throw out there that I'm a mother of 3 children, and I'm very proud of that as well too. So just give you a little personal tidbit there as well. So just so you know, I just wanted to provide a bit of a disclaimer before we get started, just so that we're clear that what we're going to be discussing today is sort of general advice around patenting. Of course, every company or every inventor's particular situation is going to be very different. And so this doesn't constitute legal advice for you or patent agent advice. This is general information about the basic principles around IP law. And for specific questions, I invite you to reach out to me or reach out to an IP lawyer or patent agent with your specific situation. All right, so let's start from the beginning, just so we're kind of situating ourselves. What is intellectual property? So intellectual property is this whole bucket of rights that includes and covers the creations of the mind. So when we're talking about IP, we're talking about inventions, we're talking about literary artistic words, we could be talking about source codes, symbols, names, images, designs, things that are not tangible goods, but intangible goods. And what IP law provides owners with is this exclusive right to exclude others from a variety of intangible assets. So in the context of a patent, it enables the owner of that patent to exclude someone else from practicing that same invention that's been patented. Or in the case of a trademark registration, you're able to exclude someone from using a trademark that's confusingly similar with you. So they're exclusionary rights, but they don't necessarily give you the right to do anything. So if you think about the example of a drug, you may have a patent to a particular compound that cures X disease, but that doesn't give you the right to actually go out and sell that compound. There's a whole regulatory framework out there that enables you to go and sell your compound. So just to get, and I think it's really important to situate the nomenclature, because when I get, highly intelligent people, they might be data scientists or, PhD in rocket science, but they still don't necessarily know the nomenclature around IP. So I think it's helpful to just sort of situate what we're talking about and use a very helpful example here. Just take a look at the Guinness bottle. So back probably 100 years ago, there would have been patents to bottle caps. Lots of patents actually around bottle caps in order to maintain the gas within a carbonated drink. And so this would have been these would have been inventions that would have been the subject of patent protection. When you look at the bottle, you also see that Guinness word mark, very famous brand in the beer business. And you also see the harp. So if you were to see a bottle with a beer bottle with a harp on it, you would probably think of the Guinness brand, because that harp is such a powerful trademark of the Guinness brand. The bottle itself also has copyright. If you look at the label, the way the label's been put together, the signatures, the design of the label, the back of it, all the written work, all the expressive work, all the artistic design of that would be the subject of copyright protection. This bottle isn't very unique in its shape, but if you think about, for example, the Evian bottle that has those glacier cutouts within the plastic, that could have been the subject of design protection. And long ago, the bottle, when it was originally designed, would have been potentially the subject of a design registration. Trade secrets would be sort of any of the confidential business information, customer information that Guinness holds. It would also potentially be the formula to making a good batch of Guinness. And so those would be trade secrets that the company might be able to maintain to this date. I mean, the formula for Coca-Cola is one of the most world famous trade secrets. And then of course the domain name of Guinness.com. And having a registered trademark actually can assist you with maintaining your domain name, especially nowadays with so many top level domains such as .biz, .ca, .cool, .this, .that. Having a trademark registration can really assist in maintaining good domain name rights, particularly in the face of cyber squatters. Integrated circuit topography, protecting the 3D configurations of electric circuits. Plant breeders' rights actually has made a bit of a resurgence now, another form of IP protection given the whole cannabis space. So there are a lot of different forms. I haven't even covered all of them, but there are a lot of different forms of intellectual property. And here's an example. I'm taking sort of an example from Instagram, held by now Facebook, as you probably know. But just to kind of break down, you look at a software company, what kinds of intellectual property might they hold and do they hold? So of course, a software company like Facebook, if we look at a particular Instagram example, would have copyright protection in its source code. Now the source code protection that it derives from copyright would not protect the ideas in the source code. So that would just be protecting the actual language that was chosen, how the coding was put together. And as you know, particularly if you are someone that has a coding background, there are many ways to code something, many languages that you can use. And so it's very particular to the particular coding. Trade secrets, so of course there would be certain algorithms, certain things that reside in kind of the black box at Facebook that would not be visible to the public and would not be known to the public. A lot of particular company information. Patents. This is actually an image here. I've got a flow chart showing an image actually taken from a Facebook patent, showing that some of the methodologies that they use that are all software enabled would be patentable. And then industrial designs, of course, some of the industrial designs would cover their graphical user interfaces. So for example, this is taken from an Instagram screenshot. This was in actually what we call a design patent in the US or in Canada, an industrial design. So it gives you a sense. And of course the trademark, the Instagram word mark is very powerful, but so are the logos. And I'm not going to touch too much on design patents, but I think it's worth noting, particularly in the software context, that we're seeing a significant rise in industrial designs and design patents in the software space to protect what are very unique and very powerful graphical user interfaces. And so if you look at this UI, this was actually this is an image taken from one of the patents, one of the Apple patents, design patents, I should say, that was asserted against Samsung. And so what you see here is the sliding to unlock a device, very powerful feature that was protected through a design patent, and ended up, obviously, if you're following any sort of patent litigation, was the subject of worldwide disputes between those two companies for many years. Google, this design patent's about to expire, but this landing page, the I'm feeling lucky button, was actually protected by Google. So just giving you some examples here of the types of things outside of patents. If we think about patents, we may be also thinking about design patents for software as well. And one of the things I wanted to just, I'm going to talk, we'll get into patenting software specifically, but why is it important is something I wanted to touch on. And I wanted to go back to an example of some IP theft that dates back about 15 years now. And you've probably heard of Microsoft, but you might not have heard of a Toronto-based company called i4i that about 15 to 20 years ago approached Microsoft about an XML editor that they were developing and had some great meetings with Microsoft about whether that product was suitable for Microsoft's suite of products. And in the end, Microsoft came back and said, well, one of their teams of developers said, actually, I think we're going to pass. Thanks for sharing, but we're not going to incorporate this technology into our products. And a few years later, i4i discovered that in fact they had incorporated their XML, SGML editor into the Word suite of products. And luckily, i4i had, before they had approached Microsoft, and actually filed for patent protection. And this i4i, of course, small software company out of Toronto, was able to, through some VC funding, was able to go after Microsoft. And this went all the way up to the US Supreme Court 10, 15 years ago. And they ended up getting a $450 million, you can search this on the internet, I think about a $450 million US judgment against Microsoft and an injunction as well in order to require Microsoft to strip out the infringing product out of the Microsoft suite of products. And this was a real headache for Microsoft. So it just goes to show the importance. Had i4i not had patents, let's say they had an NDA with Microsoft, they would have had to prove out a breach of contract, corporate theft, and would have had to show that they suffered a lot of economic damage from Microsoft utilizing their product. That's a much tougher thing to show. So just to situate you in terms of why this is important and why IP assets are becoming important, because they're actually the most important assets today. I've been part of this expert panel for the Government of Ontario, and if you're interested in understanding, why this is more important and more important than ever, I invite you to take a look at the report that we just published in February on the importance of intellectual property within our ecosystem and how we really need to be moving towards better rights acquisition within Canada in order to compete really, and I'll get into why in a minute here. So I wanted to give you a sense of how the world has shifted. So if you look here, in 1975, and you look at the value of the S&P 500, this is the US S&P 500, about 17% of the value was in the intangibles, what we call the intellectual property, as I was saying earlier. And about 83% was in the tangibles. Nowadays, the value of the intangible assets in companies is valued at over 90%. And so what is that? That is really, we're talking about the data that companies hold, and we're talking about the intellectual property assets that they hold, the brands, the patents, the software patents, the trade secrets, the know-how. So all of those sort of intangibles that the company holds are what's really comprising the wealth of these major companies today. And so that is a really important thing to understand how the world has shifted in that way. And I wanted to get into some trends now. If you look, the World Intellectual Property Office issued a report last year, and I invite you to take a look at it by just doing an easy internet search on trends in AI patenting. And it's staggering really to see, and this is actually last year's data now, so it'll be interesting to see if they do come up with another report this year to show the trends. That would be helpful. But in any event, to look at some of the largest patent portfolio holders in this space. So we've got IBM, we have Microsoft as the second largest, and of those portfolios, they're mostly owned by corporations, except we'll see that the Chinese, some of the Chinese state organizations are really moving quickly in filing patent applications in the AI space, and that's moving rapidly. So for example, you can see this chart, have a look, Alphabet, which is the holding company, as you know, for Google. They have a whole suite of companies. certainly active in that space, but IBM, Microsoft, the front runners. We have the top applicants are really active in consumer electronics, telecom, and software. 12 of the top 20 companies, interestingly enough, are Japanese, and of the 7 of the top 20 have been very active in acquiring AI-focused companies. So there's a lot of M&A activity happening in the space. And why? Because certainly the technology and certainly the patent assets are clearly important to these companies. And there's some notes at the bottom to indicate who owns what. So Alphabet owns DeepMind, Waymo, Toyota would include Denso, Nokia would include Alcatel. So that's probably helpful to see that. And then what I wanted to just color again, so if we go back here and you look, okay, IBM has filed for about over 8,000 applications last year. Last year they were granted about 9,000. You should be trying to do the math there and say to yourself, wow, of the 9,000 granted last year, they're a good majority of the patent filings now by companies like IBM and some of these other players are in the AI space. So there's a lot of activity, and there's really what I think in this industry and what many experts do is really an arms race for patents in AI and ML. And the growth rate is interesting, and if you look at who's growing rapidly, we're seeing a lot of movement from the Chinese in this space. So for example, the State Grid Corporation of China grew on average by 70% annually. So this is just sort of a wake-up call, and it's important, I think, to present this information to Canadians, because if we look at Canadians and Canadian performance within the patenting activity, it's very low, and yet Canada considers itself to be a real leader in AI, and yet when we look at our numbers in terms of patent counts, we're low, we're very low. And interestingly enough, in this WIPO report, if you do a little internet search and you search Canada, there was a commentary saying, Canada is very great in terms of research in this space, but is challenged when it comes to commercialization. And whether that's commercialization of technologies in AI into products and services, or commercialization from the point of view of patenting that technology and then licensing it. Either way, we're falling behind. So just a little bit of kind of background before we launch into it. So again, so moving away from kind of context here and why this is important to coming back now to how you get patents in this space. And so I just want to make it clear that patents, and I talked about this earlier in the presentation, that it's a monopoly. It's a grant of a monopoly by the government, and it enables you what? Not to do anything, but to prevent others from doing something. This is about you being able to carve out your market share so that you can prevent others from infringing on your inventions, on your claimed inventions, either by making it. So for example, if you have a Canadian patent, someone cannot import a product that incorporates your invention, cannot sell a product that incorporates your invention, cannot make use of your invention. So it's really, it's an exclusionary monopoly. So what is an invention? What qualifies as an invention? And I get this a lot of times because I find a lot of researchers are very humble and think, this isn't that inventive. What am I really doing here? This is this is just some theory. I'm not really even sure how I would apply this to anything commercial. But in fact, there are some great commercial applications. So what is an invention? An invention is something that is new and useful. And useful, what we mean by that is useful in the commercial context, so something that could be used and sold in commerce, of an art, a process, a machine, manufacture, composition, matter. And this definition is taken from the Canadian Patent Act, but interestingly enough, the Canadian Patent Act is modeled after the US Patent Act. So when you look at this definition, it's a very broad definition. And really, it's meant to be broad. It's meant to incorporate concepts such as software. It's meant to incorporate a whole variety of technologies, and I've listed some examples here. But it's meant to be expansive. And when the Section 2 of the Patent Act was written, and when Section 101 was written of the U.S. Patent Act, it was meant to evolve over time. Our understanding of what is an art or a process or a machine. I mean, a machine could be an AI model. Our understanding of that could evolve over time. One of the important things, though, when we're talking about whether it's new or not, means that it's not just new in the sense that no one else has created it, but it's new in the sense that you haven't disclosed it either. And so one of the important things and why patenting has to be considered early on in the development of a product is because once it's out the door, once it's in the public domain, you actually can't seek patent protection. So, one of the things I wanted to highlight is, for example, discussions with investors, those decks that you put together on your products, getting grants, research grants, those kinds of disclosures may be considered a public disclosure, which would then prevent you from seeking a patent. Having discussions with consultants, putting together some marketing material, even though you're not necessarily disclosing the invention, but you're offering it for sale. Chit chats with friends. I mean, the Facebook movie, I can't remember what it was called now, but was about, friends, a friendship that went, that went south, and, skirmish over who were the inventors there. So those, and whether there was a public disclosure. NDAs, I mean, do you have a non-disclosure agreement or confidentiality agreement in place that ensures that it's not a public disclosure? And if you do have a confidentiality agreement in place, what does it cover? Who are the parties to that agreement? Because you might be thinking, oh, I've signed an agreement with, the CEO of this company, but it's just with him personally rather than with the whole company. It doesn't necessarily bind the whole company. And maybe you have an NDA in place, but it requires you to mark everything confidential. Well, that's a pretty onerous requirement. You might be sending documents back and forth. You might be having discussions that disclose aspects of your invention. How are you going to mark your discussions as confidential? So be very careful of that, because a lot of times, I'd say half the time in practice, when I'm meeting with folks, they said, oh yeah, we've been maintaining this in our black box, and yet there's all of this public disclosure out there, and the inventors haven't realized that. The other thing is that issues around who owns the invention. So one of the things that's a big wake-up call is, by default in North America, it's the inventor that owns the invention. So just because you're working in an AI-based company, it doesn't necessarily mean that company owns the invention unless you have an employment agreement, for example, that states that you do. And so in a lot of times in startups, there are no agreements in place. You've got a whole bunch of founders, a few people getting together, coming up with, working on some really great ideas, or you have researchers collaborating with AI companies, and there maybe are not agreements in place from the start. Well, by default, without agreements or contracts in place, by default, the invention is owned by the inventor. So that's something to be very careful about. In the software context, we talked about copyright, and the subsidiary right of copyright. When you're developing source code, programmers will also have what we call moral rights embedded within the copyright. And what that means is that you actually have, if you've coded something, you actually have the right to ensure that code maintains a certain integrity if you're putting your name to it. And so unless you ensure that your developers waive their moral rights to that code, you have exposure there, because they could come back and say, look, I coded this, and then you fired me, and now you're altering it, and I have moral rights in that code, and I never waived my moral rights, and so you are going to owe me some compensation for that. So there's some things that you need in the software context to really be mindful of, and I think there's a lot of misconceptions about who owns what, and we see that across the board. So some things I just wanted to kind of highlight, particularly in the software context. And then trade secrets versus residual knowledge. So if you're, how are you maintaining those trade secrets within your company? Residual knowledge. I mean, when people work within a company, they're going to develop certain knowledge, and that knowledge typically will stay with them as they move from company to company. So how are you going to differentiate between what is a trade secret that they might take with them and what is residual knowledge that they would take with them? So there's a whole minefield in this area, but just sort of highlighting some issues. The other thing that I wanted to highlight, because we're talking about getting patents in this area, is that you don't have to file for patents everywhere that you want them right away. So there is what we call a priority system internationally. Most countries worldwide are signatory to the Paris Convention Treaty that dates over 100 years ago. There's probably some islands that are not part of that, but every major country that you would probably be interested in this space is a signatory to the Paris Convention. And so what that means is typically, if you're going after a patent in this space, you would probably file in the US, potentially in Canada to start. And then a year later, you would consider which countries you want to file in and still get the benefit of that earlier filing date. There's also something called the PCT system, which is an international patent application. There's actually no such thing as a world patent. Patents need to be sought in the particular jurisdictions where you want them. So there's no world patent. There are regional patents, such as the European patent. But there's a priority system, and there's also this PCT system, which enables you to defer filing in countries. And that can be very helpful because when you're, let's say you're an early stage software company, you're not really sure potentially who are going to be your commercial partners. So you may want to look at deferring costs for a few years potentially, at least deferring the significant costs until you figure out, where are the significant markets going to be, who are your partners going to be, who are your customers going to be, and at that point really make a decision on where you want to file. So most of our clients will file what we call a US provisional application to start. 12 months later, they'll file what we call that PCT international patent application, and PCT stands for Patent Cooperation Treaty. It's a big treaty, about 160 countries are signatory to that treaty. In that case, some notables are not. For example, Taiwan is not because China does not recognize Taiwan as an independent state. So, for example, Taiwan, if that was an important jurisdiction for you from a customer point of view, then we want to look at that. But for the most part, most of the major countries are signatory now to the PCT. As I said, about 160. So that gives you the opportunity to defer costs for quite some time. So let's get into what I wanted to do is just kind of quickly give you a sense of what is the landscape. Can you patent software? I still get that question. Oh, I didn't think you could patent software. Well, you can. What we typically call it in the art is patenting computer implemented inventions. And that would include, sorry, there's a typo there, AI, and ML inventions would be included in that bucket of computer implemented inventions. And so what I wanted to do quickly here is just sort of walk you through the state of the law, I guess, around patenting software in both Canada and the US. And we're going to go from Amazon, which was a leading decision in Canada, to Alice, which is the leading decision in the US. So we talked a little bit about Section 2 definition already, and really the issue in this area is around patentable subject matter, because there's been, and this is maybe where if you're familiar with this area, well, it's not so simple to get a patent for software. You're right, there's been some complexity added into the system, thanks to some changes in the case law. But that said, you certainly can get patents for computer implemented inventions. And thankfully, there's been further clarity in the last decade around how you do that. But a lot of the discussion has been around, well, is the patent trying to cover just an abstract idea or just a theory? Or is this something more than just an abstract theory, and it's actually got commercial utility, and it's actually patentable subject matter? It falls within one of those buckets. So a lot of the controversy is not over whether it's new, it's whether it's patentable subject matter, whether it falls, again, when I at the beginning I talked about that Section 2 definition of invention. It's really, is it considered a machine, or is it considered an art or a process? Does it fall within those subject matter categories? And so that's really where the nuance in the law lies, and where a lot of the tension and the discourse lies. Is it actually does it fall within an invention or not? So we only actually have 2 software cases in Canada that treat, software federal court cases. We have cases at the Patent Appeal Board level, but there's only ever been 2 court decisions that have adjudicated on whether a patent that incorporates software is actually patentable or not. The Schlumberger decision dates back to 1982, and essentially here you had a software method for collecting, recording, and analyzing seismic data using a computer programmed according to a mathematical formula. And a lot of us argue today that probably had that claim been drafted in a different way and had taken the output from that formula to actually do something with the data, then probably might have been considered patentable. But in the end, the court concluded that, look, just because it's a computer program does not make it patentable. and boiled it down to saying, look, all we've got here really is a mathematical formula that's being claimed, that's being processed through a computer. So that's not necessarily going to give us patentable subject matter. So that decision was interesting. And then that fast forwards us to the Amazon decision, which is from the early 2010s, culminating a decision in 2014. So here, and you're probably more familiar with this, this is the Amazon one-click online shopping patent. So with the single action, for example, with the click of your mouse, you're able to purchase a good over the internet. And this was really a significant advancement for Amazon. At the time, they were able to, through these patents, able to shut out their competitors and really make a push in the e-commerce space. So it was a significant patent. They've got a number of patents on the one-click online shopping that are still valid today and held in some of the major jurisdictions. So initially, when the case went to the commissioner said, the Commissioner of Patents in Canada said, look, this isn't patentable subject matter. This is just an abstract theory here. And we don't think there's anything more here. The federal court disagreed and said, no, this is patentable subject matter. This does constitute a machine or a process, and so fell within one of those larger buckets. And so it was the Federal Court of Appeal in Canada that really provided some guidance on how you determine whether something is a patentable subject or not. And so what they did say to the commissioner is, we're not taking sort of a form and substance approach. We're not going to look at a claim and say, well, what does it really mean? What is and this dates back to some of the British courts saying, what is the pith and marrow of a claim? What is it really telling you? We don't look at patent claims in that way. We really take what we call a propositive construction approach and analyze them based on determining whether in a patent claim the elements are essential or not essential. And I won't get into this test too much because this is the framework by which we look at a patent claim in Canada to determine whether it's got patentable subject matter or not. But one of the things that we do through this Free World Trust framework, which is a Supreme Court decision out of Canada, is we take a look at what is the intent of the patentee. And that's sort of the third prong of this test I have up here. So for example, if you go through the patent claim and you get to a point where the patentee has intended that this method be implemented by a computer, and it would be essential for this complex methodology to be implemented by a computer, then putting a pen and paper as a variant is just not going to work. And so a lot of times we will be arguing such things as the computer is essential to implement this method, and therefore you have hardware requirement in this patent because you wouldn't be able to perform this complex methodology without a computer, and a pen and paper just won't do. And so you have patentable subject matter, and then we would move on in our analysis in determining whether that methodology that performs a useful function is actually new and not obvious. So this is so what the courts really said was, look, we're not looking at whether something is focusing on or protects something scientific or technological. So even for example, software methodologies for financial modeling, for example, like in the banking industry. So fintech, for example, that may not qualify as scientific or technological. Well, that doesn't matter. We don't care about that. There are no restrictions around whether something has to be scientific in nature or technological, which is actually something that the Europeans have a restriction around. And the Europeans actually have an exclusion for business methods. They don't allow you to patent business methods. It has to have some kind of technological element to it. But in North America, particularly in Canada, we've said no. I mean, the Federal Court of Appeal has been very clear. That's not part of our law here. And really what we're looking for is physicality or some kind of discernible effect or change that's happening. So we're looking to an invention that has physical elements to it, and that the physical elements are essential elements of that claimed invention. So the bottom line that came out of the Federal Court of Appeal decision was that business methods and computer-related inventions are considered patentable subject matter here in Canada. And some quotes just taken right out of the case. No Canadian jurisprudence determines conclusively that a business method cannot be patentable subject matter. So unless the legislature, for example, unless our Canadian Parliament wants to take this on and figure out that what are the outskirts of this area. It's not for us to put limitations in this way. So in terms of Canadian practice, it has become a little bit more complex to get patents in this area, in the sense that we're frequently arguing the case law. Like when I'm putting together arguments for clients covering software patents, I'm often arguing Free Will Trust, which is a Supreme Court decision, and Amazon, just to make sure that the patent office is using the appropriate law. And patentable subject matter does include such areas as gaming, financial methods, online auctions, social media methodologies. So it includes a really broad spectrum. So just wanting to clarify that. And then what's important, because of the way our law is structured, is that you do have physical elements. And of course, even when you're talking about algorithms and implementing algorithms, they're going to be implemented using some kind of processor, using some kind of supercomputer, or you're going to need memory, you're going to need data storage. So there are physical elements here, and just making sure that when you're describing your methodologies, that you're actually including those physical elements within the patent application itself. So let's now move into the US. So we're going from Amazon now to Alice, and there are a series of cases that I wanted to walk you through quickly, because I know case law can be a little heavy for some. But let's go back again. We went back to the 80s in Canada. Let's go back to the 80s in the US and talk about the Diamond versus Deere case, and then talk about a series of cases that took us to the Alice decision, which is still the seminal decision in the area of patenting computer implemented inventions. So Diamond versus Deere. So here what you had was, it was a situation, it was impossible to measure the mold temperature without opening up the press. And the solution in this particular patent was embedding thermocouples to constantly check the temperature in a mold and feed the measured values into a computer and determine whether you open or don't open the mold. So this was held to be patentable subject matter, because you had, of course you had a formula that you were following, but based on the activities, the computations of the computer, you were actually getting a result that was providing you with some kind of outcome that was providing some kind of commercial advantage. It was solving some kind of real world problem here. So this was deemed to be patentable subject matter. And this sort of really opened up the field to being able to protect software that, basically takes an input, provides an output, and that output actually is useful to provide some kind of important commercial application. Then you had the Bilski decision. And the Bilski decision put a little bit of brakes on Deere and sort of clarified that, and this was related to a method for hedging risk in the commodities market. So again, this is in the financial space. And here the court said, look, this is not patentable subject matter. And while we do think that business methods are still patentable, and we're not going to come down and say that they're not, what we want to see is either that you've got some kind of machine here that's being claimed, or and in the case of the Bilski claims, it was really a method. There was no machine harnessing that hedging risk methodology. So they said, look, we need to see a machine, or we need to see a method that results in some kind of measurable transformation. And so that case sort of came up with this test in the US known as the machine or transformation test. And they said, look, it's not going to be the sole test, it'll be a factor that we'll look at. So is there a machine here, or does a transformation happen from one state to another for that machine? And if it does, then that will be something that we will consider in determining whether there's patentable subject matter or not. And then we get to Alice. Alice, the big decision, created a lot of confusion amongst patent agents and lawyers in the US and everywhere else, because of course the US patent tends to be within a global portfolio, your most important patent. And the Supreme Court here, because this is a US Supreme Court decision, came up with this new two-step process in order to determine whether something falls within patentable subject matter or not. And so here what you had, again, you had a computer-funded scheme for mitigating settlement risk. And this is sort of in the insurance financial context again. And so here we needed to figure out, okay, whether there's a patentable application here, because we know we're dealing with sort of abstract ideas, concepts, but is there some kind of application of these concepts that would make this patentable subject matter? So what the court said was, look, this is a two-step process. If you have a patent claim that includes abstract theory, calculations, just equations, what would really be just pure science, then what we need to do is move to a second part of the test and determine whether there's an inventive concept here. That is, when you look at the claim overall, is there an inventive concept here enough to transform that abstract idea into a patent eligible application? And so this created a bit of head scratching because they use this notion of inventiveness, which is really, this is the subsidiary parts of the test. So the first thing you determine when you're trying to figure out whether something's patentable is whether it falls within that big definition I showed you earlier of invention. Is it a process? Is it a machine? Is it an article of manufacture? And then the next step would be, is it new? And then the next step would be, is it obvious or inventive? And so newness means, has it been disclosed anywhere else, and all disclosed within a single document anywhere else, or within a single disclosure anywhere else? And if not, even if it hasn't been disclosed in, let's say, a single source, has it been disclosed enough that somebody of skill in the art in that particular area would easily be led to that invention? So that's that concept of obviousness, which is kind of the third prong. But what happened here is that the US Supreme Court put the notion of obviousness or inventive into the test around patentable subject matter. So they said, look, is the inventive concept, is it inventive? And is it sufficient to transform the claimed abstract idea into patent eligible application? So this, because they use the words inventive within the subject matter test part of this is getting a little complex, I know, but it really created a lot of confusion with how does this test get applied. And so people were sort of wondering, which way do we go here? This is a little challenging in this space. And so it really took us seeing how the Alice test was applied later on in other cases to get a sense of, okay, how is this test going to work? And so in the DDR Holdings case, what you had was a system of serving web pages. So this was dealing with the issue of when you're on the internet, when you're searching for a product on the internet, a particular platform will want you to stay within their platform, even though you might be going to someone else's website to get certain information. And so the way they do that, or the way that this particular application worked, was that it enabled you to stay within their website, but create a new web page for the content of that different website. So enabling that consumer to stay within that platform, but still go to various different web pages and still come back to that same platform or stay within that platform. So it was a novel solution. And but the issue was it included sort of abstract ideas, business ideas that it wasn't clear whether this was patentable subject matter or not, because abstract ideas cannot in and of themselves be patented. And so what the court said here is, yes, there's something more, because what you have here is a solution that actually solves a computer network problem, because, and this is the something more that they're looking for, because by solving a computer network problem, by maintaining someone within your own platform, you're actually reducing the network load. And you're creating more efficiency in terms of bandwidth usage. So they kind of likened it back to creating efficiency within the internet and creating, increasing speeds for users, because you were staying within that same platform, within that same website to get all of your content, rather than moving out to another website and slowing down the network. So this was considered a valid argument, and this is how they then moved to the next steps of the test, which are, well, is this system of serving up web pages within a website, is that actually new? And it was new. And is it obvious? And it was deemed not to be obvious. But it got through that first hurdle of, it's not just protecting an abstract idea, there's a solution here that really solves a computer network problem. And then there was also the ENFISH decision that was helpful too. So this was a method here for a self-referential table for a computer database. That was the invention. And here again, the federal court in the US said, look, this is what we're doing here is, although we're including some abstract theories here and formulas and lots of calculations happening, it's really an improvement to an existing technology in the computer database space. And what we see through this methodology, the something more, is that there's increased speed and flexibility and reducing the memory requirements, which is very helpful. So the federal court in the US also said, look, there isn't a technological art requirement in the US. So even though we know that this concept exists in Europe, we're again not gonna subscribe to that. So that was helpful to understand that it's not necessarily, I mean, some would argue that in the US, it should be technological in nature, the invention, but that's not written into the law at this point. And so the USPTO, the US Patent and Trademark Office, has provided some guidelines to help us sort of understand whether your computer implemented invention would be considered a subject matter sort of patentable subject matter, if you will. So the first thing you would ask is the claim to a process or a machine or manufacturer composition matter? And if it doesn't actually, if it's not a method of doing something, or it's not a machine, or it's not a system, let's say, then it's just not going to be eligible subject matter. But if it is, and you're not just claiming just an abstract idea, then you would go to step 2 of the question for Alice. And the first part of the step 2 would be, is the claim directed to a law of nature or a natural idea or an abstract idea? And if you do have abstract ideas within that claim, so it's a method of doing something that incorporates an abstract idea, then what you would do, the patent examiner would analyze this next step and say, does the claim recite additional elements that amount to something significantly more than the judicial exception? And if so, if there's something more here, if you're solving, for example, a computer efficiency problem or a computer network problem, that's going to qualify as eligible subject matter. So what we do a lot of in this area, particularly in the US, is we tend to take our software patent cases and we liken them to some of these court decisions that have come out to say, look, we're a lot like ENFISH, we're a lot like DEER, to help us get through these hurdles. So there is more sophistication when it comes to patenting software in this space, but it's certainly doable. And as I showed you with a lot of those patent filings and those patent numbers, you can see that many companies have figured out the art of getting software patents. And there's been even more good news recently coming out of the US Patent Office as well, because the guidance for patent examiners, for US patent examiners, is becoming more stringent. Like, we were going through a period where patent examiners in the US were giving us a very difficult time around patenting computer implemented inventions, and it's getting easier, and even in particular in areas that include organizing human activity and business methods and areas such as this. And the key, is that one of the guidance that came out of these guidelines was, look, if you do have a judicial exception and you do have some kind of abstract idea that they're trying to patent, is it integrated into a practical application? And if it is, then you have patentable subject matter. And that has been hugely significant since 2019. So when we've been looking at patenting various inventions, including in the AI space, we're saying, look, yes, there's some abstract theory here, but what we're doing here is applying it to a practical application of being able to process images faster for image recognition. We're using it for improving the speed by which users can access this application. And so by showing that there's a practical application, you're really able to make a lot of headway in your arguments with the US Patent Office. So in patent claim drafting, and in patent drafting in particular, what we aim to do, even though business methods, for example, in North America are not considered not patentable, you still, it would be best to still emphasize that what you're trying to do is solve a computer problem, even if you are trying to solve a business problem as well. So we do spend a lot of time when we're drafting patent applications providing, sort of hardware requirements. We do detail processors, servers, database. Interaction, inputs, outputs. Like we spend a lot of time talking about some of the physical elements because, of course, nothing sort of lives without having access to some hardware. And then we do state some of those physical elements in the body of the claim. And so you'll see that I'm actually going to just pop up a few examples here of cases that our firm has drafted. And then try to show that there's been a discernible effect or change, coming back to some of that US case law, and have your methodology interact with the hardware in some way. So you're going to have, if you're using large sums of data, you're going to have that data stored in a database of some sorts. Well, you're going to mention that in your patent claims. And then what we do is we avoid, instead monopolizing, a theory or an abstract, just an abstract theory or a principle, and try to focus on, okay, we're taking that particular theory and we're using it to solve some kind of practical application. And if you focus on the practical application, and you can have many practical applications, and the practical application can be quite broad, but by focusing on the practical application, you're able to get patents in this space. So one of the things I wanted to do, and I'm hoping that this is going to work, is open up some of these patents here. So this is one that's already been patented, and that's actually a local company. And I'm wondering if, Lucy, can you just pop in and tell me if you can see the PDF, or if I failed in that regard in terms of sharing my screen?
No, I don't see the PDF.
Okay. Let me just stop the share and try to share this again right here. Okay. Sorry, bear with me a moment here. Okay, so can you see, Lucy, can you see the US patent here? Okay,
Yes,
great. Yeah, perfect. Okay, so this is an example. This is actually a local company. And I wanted to just show you a couple of examples just to kind of color this a little bit. And you're going to have, we'll have a few minutes now for questions, but I'll just kind of flip through these quickly. But, this is, for example, this is a patent that is focused on a method of image manipulation to create training data sets for AI systems. So this is something that, you could kind of flip through and you can see what's going on here. We're using different training sets. And what I wanted to do is kind of flip through the patent and give you a sense of, the flow charts, maybe the simplicity of patent applications to what they cover, but give you a sense of kind of the flow charting and how we take sort of some, we take the theory and we sort of abstract it enough so that it's it covers things in broader terms, let's say. And I'll just kind of flip right now to the patent claim, so you can, and the claims, as I said, so this is a description of the application I'm flipping through a little quickly. And then at the end of a patent, this is what sets out the monopoly of a patent. So in this case, what we have is a method for image manipulation comprising, you receive the image, you obtain a clean image, you extract a feature image, you determine specific characteristics, you generate new features of interest based on those specific characteristics, you generate new feature images, you combine said new feature images, and then you use that new image data set for training an AI system. So this is an example of one methodology, and this is now the subject of a US patent. I'm just going to flip through to the next one here. And I'm going to go to another one that's kind of interesting too. Bear with me a second here. Oh, sorry, just to give me 1 second. I'm just going to share my screen here and show you. Okay. Sorry, so Lucy, can you see this now?
Yes.
Okay. Perfect. Okay. So this one is kind of a more sort of, I'm not going to flip through this too. This is a little bit more kind of I would say, math intensive, but kind of just gives you a sense. So we've got systems and methods related to machine learning by using a sample data set to learn a specific task and using that learned task on a query data set. I'm just going to show you here the abstract, and then I wanted to flip quickly to the claims, just to give you a sense of that and sort of how we abstract something that is obviously includes a lot of theory and how that would be claimed in a patent. So I'm just going to come to claim one. So claim one here, and you have the links to these, is a system for performing a task, the system comprising a task representation stage for representing said task and for encoding a representation of said task using a set of generated parameters, a task execution stage for executing said task on a query set using said parameters and for executing said task on a sample set, outputs of said task being compared to determine a similarity metric and an output definition stage for scaling said similarity metric using a learnable value. So just kind of shows how we abstract, and this would be this. I mean, if this patent issues, this will be the outskirts of the claim. And then final one, which is kind of a fun one, is this one. I think you can see this now. It says counting objects.
Yes.
Yes. Okay. So this one is about counting blobs. Literally, we claimed counting blobs, and you'll see here what we're doing is we're counting penguins and counting people, and what I'll do, and you have these, you can, I mean, I invite you to take some time to look these over, but this is, it's kind of interesting, counting object blobs. And why I wanted to kind of end on this note is, and I'm just going to come to the claim here just so we can read the claim together. And this is one of our favorite ones within the office. So it's a method for counting objects in an image. Said method comprising the steps of receiving said image, segmenting said image into at least one object blob, each object blob being an indication of a single object, and counting said at least one object blob to thereby result in a count of said number of objects. Wherein the segmenting of step B is performed using a neural network, and wherein the neural network has been trained to perform said segmenting according to the following steps. But the claim, if we get the patent as it is, it will have this particular scope here. So just to kind of give you a sense of the types of things that can be patented. This is in the public domain now and readily searchable. So just to give you a sense, but also what I wanted to point out here too is this is a challenging area, because what skilled patent attorneys are doing in the space is they are developing, they are becoming their own lexicographers, and they are developing their own vocabulary in these things. So if you were to do a patent search and you were coming up with a methodology of counting objects and you want to see what patents out there, you might not find patents that you were looking for because you're not using the terminology that the patentee is using. And you can be your own lexicographer patents. You can define terms and say, this new term means this, and draft a whole patent application that covers something that perhaps others wouldn't recognize in the field because they're not referencing it in that way. So there are ways to really obfuscate inventions covered in patents so that you don't necessarily find them unless you're a trained eye and you know what you're looking for. So this was just hopefully to give you a sense of what we're doing and what kinds of things may be protected here. It's just a small sample, and hopefully by seeing the numbers that gave you a little bit to think about as well. So do we have, Lisa, do we have any questions?
Yes, we do. Thank you, Natalie, for that presentation. I'm just going to start my video here. So we have, it's quite a long question here. VC firms that support patent disputes are often referred to as patent trolls. The naming has a negative flavor, but the costs and IP market actually calls for these entities to become important players and support costly cases for small entities, such as universities, particularly against large corporations. Could you elaborate on the pros and cons, particularly from a Canadian university point of view?
It's funny because if you do if you do an internet search and you look for Natalie Raful Globe and Mail, I've actually spoken to this point. I think that what we lovingly call patent trolls or patent licensing firms, and we have some very famous Canadian examples such as Wyland and now Conversant, formerly Mossade. These are companies that acquire patents, and I mean, universities to some extent are patent trolls as well, right? Because they're not operating companies. Sorry, so I should clarify for folks, when we say patent troll, we're talking about companies that are not operating companies. They don't sell products and services. They derive their income from licensing patents. And so there are many examples of that. But if you look, a lot of operating companies now are spinning out arms of their companies, subsidiaries that hold the patents, that are out there trying to actively monetize their portfolios. And I think that this is I think this is part of keeping the ecosystem honest. I think over the last decade, we've seen actually a lot of what I would call crappy patents get invalidated, which is not a bad thing. So, patent quality is not always there, but I think they serve an important function, because when you look at some of the patent licensing firms, a lot of times, many of the portfolios have been acquired from SMEs. And sometimes investors, when they see that a small company has a patent or a patent portfolio, that can be very enticing, because they know that, let's say the startup doesn't make a go of it, at least at the end of it, there's a patent portfolio there that they might be able to monetize and might be able to get some money back from their investment. So it provides a certain level of insurance. So I know VC firms want to see that. So to answer your question, I think patent licensing firms are a healthy element to the patent ecosystem. I think they're necessary because they serve an important function also for, universities to some extent are trolls, although, many of them don't assert their patents, but some do, particularly if you look at the US now, you're seeing a number of universities that have been embroiled in cases, and you're seeing more and more of that activity. But I think it's an important function to sort of keep the ecosystem honest. So that would be my comment on that. And then limiting patent filings to some jurisdictions is often a necessity, and you're quite right. And so I say to a lot of companies, if you can only file in one country at this point, you would file in the US, because I would say that North America certainly has the sort of most robust provisions around patenting and software, lots of case law there. Europe would be kind of the next jurisdiction, but if your application is a little bit more business method oriented, you're solving more of a business problem, maybe you're working in the insurance space or financial tech or whatever kind of area you're solving, the case law is perhaps more in your favor in North America than it would be in Europe. But and also this is at this point, the US is the largest market. So if you have to retreat, I would say focus on the US as an important market. As a cost deferral strategy, PCT is great. That buys you, as a company, particularly if you're a startup or early stage, it buys you 2.5 years before you have to decide which countries you want to file in. So there are lots of great deferral strategies. And I would say at a minimum, focus on the US, and then branching out from that, I would say Europe and probably China at this point. And there are things that you can obtain, such as utility models, which are cheaper patents. So in China, of the millions of patent applications that are being filed in China annually now, half of those are what we call utility models. They're patents that are not examined, so they're cheaper to obtain. And a lot of folks now are implementing a strategy where we're filing full examined patent applications maybe in the US, and then just filing a utility model in China, just so you have some coverage. And then if you do have a skirmish with a Chinese competitor, then you would take your utility model and you would have it examined quickly and efficiently, and then try to enforce it. Hopefully that was clear.
We have another question regarding the timeline. So what is the timeline for patent process? How long does it usually take in the average process?
I tell folks to think about 3 to 5 years typically, particularly if you take the PCT route, right? Because you're going to be pending, basically, not incurring too much cost. Like, to get to that 2.5 year point, let's say you follow what typically my clients will do, which is US provisional filing to PCT. You're probably looking at about 2.5 years there of pendency, about 20,000 maybe of investment at that point over those 2.5 years. And then at that point, you're going to go national phase. And usually you're looking at 6 months to another 2 years, 2.5 years to get your patents.
Okay, thank you. We have another question. Don't you think that the change in vocabulary in patent application will only make prior art searches more difficult and lead to more patent infringement cases? Because if two different patents are linked to the same application or function, but they only differ in language, you might increase the number of assignees losing their patent.
Yeah, so just because you're your own lexicographer, as I showed you with the counting blobs, doesn't mean that the patent examiner is not going to be attuned to that, right? So I think, I mean, you still go through patent examination, you get put into a particular, every time you file a patent application, it gets assigned a particular art unit, like a classification area, and your examiner is going to be skilled in that art. So your examiner is going to be seeing applications, and he's going to be seeing all of that lexicography that's going on. And so he's going to be well aware of that. So from an examination point of view, it's not as much of a problem, but it's a problem for the layperson who's not really entrenched. So for smaller companies that are not as patent savvy, you need to understand that patent searching it can be complex, and it can require you not just searching keywords, which is what everyone tells me. Oh, I went into Google Patents and I searched by keyword. Well, that's great, but did you search by classification? Because patents are classified. And if you're not doing a classification search, you're going to miss that lexicography. You're going to miss those terms that savvy patent attorneys for IBM and other big companies are using, and you're going to maybe find yourself exposed.
Okay, we have another question here. Is there any fair use rule for universities or nonprofit organizations for using computer implemented inventions in Canada or in the US?
So fair use is a great question, because that's a concept, the fair dealing exception, it's a copyright concept. No, patent infringement is patent infringement. There's not like a research exemption. So I would just, you got to tread carefully. Now that said, a US patent cannot be enforced in Canada. So if you're a Canadian university, I always say, you're showing me a US patent right now. Is there a Canadian counterpart to this? Is it an application? Is it patented? Because Canada is a secondary jurisdiction. So the company has to take the time to not just get the US patent, but they have to get the Canadian patent. So that may be an area where, when you're looking at all these patent filings globally, are these big entities taking the time, or what's included in their patent portfolio? I can tell you that AI filings at the Canadian Patent Office are certainly up, but you may want to look whether there's a counterpart patent in Canada when you're doing your research. But you do need to be attuned to this, certainly.
Okay, thank you. So I think that concludes all the questions. And thank you again, Natalie, for this very interesting webinar. We really enjoyed it. I'm sure that our participants enjoyed it as well.
Great. I popped in my email in case anyone has any further questions, and you know where to reach me.
Perfect. Thank you very much.
No problem. Take care, everyone.
Bye, everyone. Thank you. Bye.